more slides, but I want to go through the slides first in general, and then the most important thing is I want to highlight a few items that you need to be aware of regarding Lautenberg. Okay, there's a lot involved with this, and our security forces folks, probably know just as much or more than me on these issues because it impacts them directly if something were to come up. So, okay, slide. Okay, we're going to just overview we're going to provide an overview of the purpose. What is a qualifying conviction? That gets a little tricky. Effects of a qualifying conviction, and then we'll sum it up. Okay. Next slide. Okay, prohibits anyone with a qualifying conviction from owning or possessing a firearm. No military exception. So if you're in the National Guard, you're reservist, traditional, you're Title 10, whatever, it doesn't matter, no exception. If you carry a weapon for your job, it doesn't matter. Prohibits the military from issuing a weapon to a person who is reasonably believed to have a qualifying conviction. Okay, next slide. Okay, what is a qualifying conviction? Okay, first thing you got to understand here, and there's a DOD instruction, of course, on this for domestic violence issues related to the Lautenberg Amendment. The use or attempted use of physical force or the threatened use of a deadly weapon. So let's say, I'm going to come back to this, but I see this a lot in my court in town of Frankfurt where I'm a judge. You have a domestic incident, it happens. Right? Let's be realistic. Okay? Your spouse, you guys get in an argument, the husband shoves the wife or vice versa. She calls the police. Husband gets charged with disorderly conduct or harassment second, right? A violation. Not a crime. It's a violation. I'm going to ask the question now. I want you to think about it. If someone's charged with disorderly conduct or let's say harassment second because there's no physical harm that's actually attributed to that person that they shoved. They just shoved them, which is bad enough, but they don't cause any black and blue injury or any to bleed or any manifestation of injury, so you don't go to the level of assault, correct? Right, so now you're at a violation, harassment second, punishable up to 15 days in jail. The question I'm going to ask you now, and I want you to think about it, is if that person goes to court and is found guilty, either in a trial or plea bargain, not a plea bargain, you plead the charge. If they plead guilty to it, they have a conviction for disorderly conduct. Is that a qualifying conviction? Just think about that for now, okay? We'll get back to it. When committed by a current or former spouse, parent, or guardian of the victim, or attempted use of physical force. That's a good point. Let's say the person pleads guilty to attempted harassment second, right? You hear people getting convicted of attempted assault. Right? You're not pleading guilty to the assault, but attempted. Okay, that's another point. Attempted use of physical force, or the threatened
swing and a miss.
Swing and a miss, exactly. Yeah, I don't see a lot of convictions for attempt unless they're plea bargained down. So if someone were convicted of, I'll give you an example, attempted assault third. Assault third is a misdemeanor, punishable by up to 1 year in jail. Okay, you clock somebody in the face, you bust their nose or whatever. If you plead guilty or you're found guilty, they can give you up to a year in New York State. Okay, local time. Let's say it's an attempted. It goes down to a Class B misdemeanor. Class A is up to 1 year. Class B is less punishment. You see how that works? It just lowers it by one. So, like Colonel Norton said, you swing and you miss. Realistically, are they going to push that charge? They may reduce the assault or the harassment down to attempted for plea bargain purposes, but that's important though in terms of the law. So, the person with whom the victim shares a child in common. Okay, this is pretty easy. Right? You're not married, you have a child in common. That person who is cohabitating, so you're living with someone, or you did live with someone. Victim cohabited with a victim as a spouse, parent, or guardian. Person similarly situated to a spouse, parent, or guardian victim. That leaves some room for litigation, but similar situation. We won't worry about that. I won't convolute everything for you guys today on that. Okay, next. Here we go. Includes all misdemeanors that involve the use or attempted use of physical force if the offense is committed by one of the defined parties. That's why I issue this disclaimer. I never use this simple assault. New York State, so I'm not sure what we're talking about there, but assault is an assault to me. So disorderly conduct, simple assault, assault, and battery. We don't really use battery in New York. We don't assault. It's either assault or it's not, unless the conviction is expunged or removed. Now, this is an important point. Some people will move to get their conviction expunged or removed. They would have to make a motion to vacate the conviction. Sometimes it's done several years later. You're young, you're 18, 19 years old. I got a client now that endangered and welfare, domestic issue, a shove match. That's all it was. I don't say that's all it was, but it's leading to a lot of problems for him. Years ago, there was a child that was nearby. Nothing happened to the child. Child wasn't at risk of any injury at the moment. There was a shoving match that went on. He ended up pleading guilty to an endangered and welfare several years ago. He's still having trouble now getting jobs because he's got this endangered and welfare conviction. One blemish on his record. Now, I'm not saying what he allegedly did was right. So what he's trying to do is he's asking, can you make a motion to vacate the conviction on the basis of I've applied for 20 jobs and I can't get one? And this is a blemish on my record. Is there any way that in the interest of justice, the court would change it? They don't have to change the conviction. Because if you pled guilty and you only voluntarily pled to the charge and you understood your rights and you had a lawyer, or you waived your right to a lawyer and your rights weren't violated, then the judge doesn't have to. Why would he vacate the conviction or she vacate the conviction, right? Sometimes they will in the interest of justice. You see that a lot with young kids that get in trouble, they're teens. And that one misdemeanor conviction can follow them forever. It's sad if it does. Even applying for a job at Lowe's or Home Depot, they do security background checks. It shows up right away. So it's a tough situation for us. I didn't mean to get off on another note there, but I guess that's my point. Unless it's expunged or removed, vacated. Okay, next slide. Okay, continuing obligation to report a qualifying conviction. It's on the member. I mean, you should know if you have a qualifying conviction. You should know. Okay, ignorance of the law is no excuse. Individuals with a qualifying conviction shall not be granted a waiver for entrance into military service. So if you have a qualifying conviction, you can't get a waiver for that, enter military service. Retrieve all government-issued firearms and ammunition. Okay, so if there's an issue that comes up, you have to retrieve all government-issued firearms and ammunition if you were issued, of course, under military authority. Suspend the authority to possess government-issued firearms or ammunition. What's the other issue in this case? Let's say we got a Lautenberg issue for somebody. What's the other threat to their security clearance, right? It's another issue. So it's not just that we're going to take their firearms away. There might be an issue with the security clearance where we may need to be reviewed, and they may end up getting their clearance suspended.
But these five this will happen.
Yes, sir.
Right.
Yes.
Okay.
If it's a qualifying conviction. And we'll go through that a little more. Must dispose of their privately owned firearms, ammunition, lawfully. They're not supposed to have possession of your privately owned firearms too, and ammunition. Okay, next. Well, kind of talked about this a little bit. A Lautenberg offense may lead to adverse personnel actions, including separation, various reasons. Separation will comply with sanctuary provisions. I believe I have the AF5 recently, 3631. I think if you have 18 years or more, you're in that sanctuary bucket. What that basically means is if you're in that sanctuary bucket and your discharge proceedings are initiated against you, you have to go through SAF approval, okay, to be discharged from or whatever unit you're in, status. No access to firearms and ammunition. Now I'm probably jumping ahead. Anybody got an idea or want to tell me what do you think about in terms of what kind of firearms? What firearms are we talking about? Anybody besides us security folks here? Sorry?
Personal loan?
Any firearms. Even if you don't need a license or a permit, pistol permit, any firearm at all. Right? Long guns, shotguns, rifle, anything. Okay? That's really important because when I get into the order protection issue briefly, I won't go on too long, but I issue order protections in my court, and if somebody possesses firearms, I can have them moved immediately, when they come in upon arraignment. If I issue an order of protection for them to stay away from somebody, It's a very tough situation, folks. You got to remember, people with domestic incidents, it could have been the first one they had at their home, and now you have to make a decision. Me as a judge, do I remove this husband or wife from their family, like physically remove them for an alleged harassment case? I'm not saying it's not bad, but I'll say it's a he said, she said, shoving match. Do I remove this spouse from his home, put him on the street, or do I issue a refrain from order to refrain from any harassing, assault behavior? It means it's modified. You can physically be around that person, the alleged victim, but you can't. You have to stop engaging in that alleged activity. Now, by issuing the order of protections, I'm not saying that person's guilty of anything. It's a reasonable cause to believe that it should be issued during the pendency of the proceeding. I have reasonable cause based on the allegation. Doesn't mean somebody's guilty or not. Does everyone understand that? Okay, I would issue an order of protection to the judge. They're usually issued not because the judge thinks that person is guilty or committed those offenses, but there's reasonable cause to believe that it should be issued to protect all involved based on the allegations that are put forth in supported depositions. Okay? All right. I'm trying to just put in some practical knowledge here of what I go through as a judge. It's not easy to make those decisions, especially 2 a.m. when I get called from an arraignment. There was an argument in someone's house, husband and wife, got kids involved and everything. So obviously if it's a serious offense, more serious than maybe a shoving match, I may remove the spouse temporarily, do like 3-month order of protection or something. And I'm now going off a tangent here, but another issue is I have to deal with the other spouse coming in when they make up the next day. They want to waive the order of protection. I don't want it no more. We made up. Everything's fine. Well, you got to be very careful to not want to agree. I don't have to waive it. Because what if I waive it and something happens bad? Who's it coming back? Okay. I know I got off line over here, but it's kind of important. It's relevant, these order of protections to the Lautenberg Amendment. That's why I'm bringing it up. Okay, next. What should you do if you are convicted of an offense involving the use or attempted use of physical force or the threatened use of a deadly weapon? Anybody have any thoughts on that?
Notify your supervisors immediately.
Yes, go to your supervisor, check with them. You can check with the JAG, myself. You need to really be responsible for knowing whether or not you're in violation, especially if you authorize to carry firearms in the military, okay?
Should you wait for conviction or should you not
Yes.
advise you're arrested?
Good point. There's a couple instances, there's one for sure, the order of protections, where you don't need the conviction. Okay? If an order, I might as well get to it now, we'll come back to it. If there's an incident involving your spouse and you're issued order of protection, refrain from harassing behavior, stalking behavior, disorderly conduct, anything like that, an order of protection is issued against you, we got a problem without conviction. Great question, sir. Okay? See how this ties in? Okay. Doesn't have to be so-called conviction, all actual conviction in court. The conviction in court is either by a jury or judge finding you guilty beyond a reasonable doubt of a qualifying offense, which is generally speaking a misdemeanor or felony, which I'll get into. Or if you have an order of protection pending, you got a problem on for it. Okay? All right. Okay. My civilian attorney pled me down from a conviction of domestic battery, which we don't really have, to a disorderly conduct. Do I still have to report this? Keep that in mind. All right, next slide. Okay, these are the references. 18 U.S.C. 922 outlines the Lautenberg Amendment to the Gun Control Act. And that's important too, the DOD instruction, domestic abuse involving DOD military and civilian affiliated personnel. I want to go over with you now, real briefly, some of the key points, which I probably already talked about a little bit here. You have to keep in mind, okay? But these are the two references that you should be familiar with. Supervisors and command leadership and everybody in general should be familiar with it, okay? All right, a couple things I want to go over. I made notes of here. So the way the crimes of domestic violence are basically defined as the term crime of domestic violence means an offense that has as its factual basis the use or attempted use of physical force. We talked about that a little bit, right? Or the threatened use of a deadly weapon, menacing charge, You know, somebody gets a knife or even anything, and they threaten to hit somebody with it, right? That's a threatened use of force. They could be charged with menacing, which is the very least a misdemeanor under the law, New York State. Okay, that would qualify. Current or former spouse, we talked about this, parent or guardian of the victim, by a person with whom the victim shares a child in common, we talked about that, by a person who is cohabitating, so I'm not going to go through everything, we kind of covered it, but you know the relationships that triggers it, okay, as far as protected persons. All right, a couple more points I want to bring up. Firearms, I talked about that, includes any weapon, including a starter gun, any weapon at all. So you can't say, oh, I got my hunting rifle, I don't need a pistol permit for that. That's okay. How about possession? Let's talk about constructive and actual possession. Let's say that you say, well, you know, I'm not in possession of my gun. My wife has it. She stored it. It's in the attic of my house. I never touched it. You know, I'm not going to go put my hands on it. What do you think of that?
Not allowed.
Not allowed. Constructive possession. If you have access, if you can walk, and you can walk upstairs into your attic and grab that gun, you're in violation. Constructive possession. Okay, so that ain't going to work about this. Well, I don't really have physical, actual possession of it. That's important. That's in this DOD. It's a really good instruction. DOD, it's up there, 6,400. It's been revised recently, about 50 pages. Okay, what else do I want to qualifying convictions? We talked about that a little bit. Okay, this is important. A qualifying conviction, here's an example. A state or federal conviction for a misdemeanor crime of domestic violence. Now you asked the question, what's a misdemeanor crime of domestic violence? You got to go to the definition of domestic violence, which we talked about, right? The threat of force, the use of force against one of those protected parties. That's how you tie back into what the crime of domestic violence is. Okay? Don't worry, it took me about 6 months in law school to figure out all this stuff. So everyone's looking at me like, okay, here's another example. A state or federal conviction for a felony crime of domestic violence, similar circumstances. So you get a federal conviction, all right, as long as it fits. Here's a more trickier one. A general or a special court-martial conviction for a uniform under the UCMJ. So let's say we have a member that's Title 32, he goes on Title 10 orders, he or she, and let's say, I know we don't deploy a lot in our unit, but you could be in Title 10 status and do something really stupid. Okay, you're on Title 10 orders. Well, we dispatch you to the 201st Mission Support Group because you're ADCOM control 201st. Andrews Air Force Base court martials you. Okay? Remember, folks, you could be, if you're in Title 10 status here, you're on orders for a year, you do something really stupid. Okay, you're dumb, you're getting yourself in trouble. It's bad enough that we can technically be court martial, okay? Through Andrews Air Force Base, the 201st, you're going to be assigned to the 201st Mission Support Group. Okay, my point is, let's say you do something really stupid with your spouse and you have a domestic violence incident and it leads to a special court-martial conviction for assault. Well, that's a qualifying. Everybody understand it? Okay. Let me see. Now, here's the trick. Okay, it doesn't qualify unless you're represented by counsel, you went through a trial, or you waived your right to trial, and or you waived your right to counsel, and or you had competent counsel. And so there's these conditions, of course, that are attached to it, but they're obvious conditions. Right to counsel, as long as your rights were protected. You either pled guilty. If you pled guilty and you voluntarily pled, you understood what you were pleading to, that's enough. You don't have to have a trial. You just have to be afforded the right to have a trial. Okay? And then there's other areas, which I'm not going to get into too deeply here, but there's restricted reporting and there's unrestricted reporting. The victim's advocate, okay, you got to be aware of that in case there's a military member or even a civilian member that can be afforded military services, the protection of military services, that there's a victim advocate that can be you can do a restricted report to. But be careful, because if you're an alleged victim of domestic violence and you start reporting it throughout your chain of command, well, that triggers an unrestricted report, generally speaking. Okay? So just keep that in mind too. So if you want to keep it quiet, you want to keep it initially protected, you got to go through the designated victims advocate. Okay? Is this helping everybody?
Yes.
I know I'm throwing a lot at you. Also, our commanders can issue protective orders too, if need be. Okay, I don't have all the details right now. I'll have to research it, but just commanders can issue a protective order if you have a spouse. Probably have to find out what the qualifying jurisdiction would be, but probably have to. I'm not sure if it would involve 2 military members, but I'll look into that. But the protective orders can be issued for stayaways or refrain from harassment and so forth. Any questions at all? I've been rambling on a little bit. Sure.
I just know of someone in another state. They're actually under conviction but it's under self-defense. They actually had their own child and husband attacking them, and because they are military, they're trained. They actually were trying to use that as self-defense, and now they're going against them.
Is the case still pending? Wait, so you have 2 military members or one?
Nope, he's civilian, child civilian, and she's military.
She's military. She's the victim.
Yep.
Okay.
But she obviously used force because she was.
I see what you're saying. Okay, so everyone understand the example here? We got the military member who was using self-defense because she used some type of axe to protect herself, obviously, from getting beat up or whatever. An axe. Not axe. Some type of overt action. That must be my Utica slang that came out. Acts of violence. I need to be corrected once in a while. My wife always tells me that. What did you say? So if the case is still pending, then you're right, she's trying to challenge the Lautenberg because she's saying self-defense for conduct. That's fine. She's not convicted of anything yet. However, what's the trigger here? Case pending. Bingo.
Say that again?
Yes. Order protection.
Right.
They both probably have mutual order protections, possibly to stay away from each other, right? So she can't carry what?
An axe.
There you go.
So-
Thanks, Chief. I think it's the hand. Yes.
That's all right. Look, does that also mean they're non-deployable then at that point? Or does this only apply stateside?
Well,
You got to
See-
carry a gun. You're not deployable.
exactly. Yeah. See, in Syracuse, when I was in Syracuse, and Colonel Belpier shed more light on this, but I always had to keep up my qualifications because of my status at Syracuse. I was civil engineering squadron. Even as a JAG, I had to keep up. I had to fire the M9. And I think we probably still have to do that here, but I haven't called in a while to keep up my qual. So I don't know if it changes because of the status we're here at this unit. I'm not sure. But certain positions you're in. But yeah, if you can't deploy without your certification being up to date. You can't possess a weapon. You can't deploy. Okay, and then you got other issues. They might put you on a hold for security clearance because you got domestic violence charges. Okay, good question. Any other questions? Sure.
So where's the checks and balances for orders of protection? Just kind of get it.
Yeah. Problem is, you're really without much control because that town or village judge, like myself, or family court judge, that's where it all starts. They make the decision to issue the order of protection, right? If that order of protection affects a unit member, and that order of protection is for that unit member to stay away from somebody, or to refrain from certain acts, which is a modified order. It's called a refrain from order. You got issues with the Lautenberg until the judge releases that order. We usually do temporary orders of protection for 3 to 6 months. Misdemeanor cases typically last 3 to 6 months in my court. If they're felonies, they're going to go up to county court anyways. I only have limited jurisdiction over felonies. I can arraign somebody on a murder charge, so to speak, in my court, but it's only going to stay there through the preliminary hearing, then it goes up to county court. Okay, I can't accept any pleas to felony charges in town or village courts across the state. Every judge, just so you guys understand how that works. In city courts too. But did I answer your question on that? So basically, if the judge cancels the order or withdraws it, or if it expires, then technically, if that person's not convicted of any qualifying conviction, then they're okay under Lautenberg. So there may be a temporary suspension under Lautenberg that direct Colonel Phil Korn to issue, an order suspend the use of firearms due to pursuant to Lautenberg. Trying to think what else. Oh, so getting back to the disorderly conduct. Anybody?
Yes.
How about someone's charged with disorderly conduct, but they're not? But it's not disorderly conduct. I'm sorry. Let's say it says disorderly here. Disorderly conduct without an order of protection. What do you think? No order of protection. What if they plead guilty to disorderly conduct, a violation, not a misdemeanor?
Is that a yes? Maybe.
Maybe. What did we talk about earlier? I know we got to wrap this up. But what did we talk about? Misdemeanor, right? It has to be. Bear with me here. It's got to be a misdemeanor under state or federal law, punishable up to a year. Rising on domestic violence. So would that technically apply? Shed some light, sir. What are your thoughts on it?
Maybe misdemeanor, I think, conviction.
Do you think that the disorderly conduct conviction would be enough without any order of protection?
Something about the water.
I agree with him. The way I read it now, I may be wrong, and I'll double check this. But the way I see this right now, and I'm just looking at the way the law is here. I could be wrong on it, but I don't think it would be a qualifying conviction unless it involved an order of protection. A straight violation of harassment, second, or disorderly conduct, unless it involved an order of protection. Because if you get convicted of the disorderly conduct, it's a violation, punishable up to 15 days in jail. It's equivalent to going out in the street and yelling and screaming like a nutcase in the middle of your neighborhood if the cops come and arrest you, right, for disorderly conduct, and you're found guilty of it. Now, if it involves an order of protection because you're fighting your neighbor, you got a problem. Because that's another area we can bring this in. Does everyone see how that works? I'll double check on it, but based on the qualifying convictions, a state or federal conviction for a misdemeanor crime of domestic violence. Be careful. We have the domestic violence elements in there, but do we have a misdemeanor? Follow me? We have those elements. We have a spouse, a former spouse. We have a pushing and shoving match. We have threats of violence. But we have the individual charged with only a violation, with no order of protection, assuming the judge doesn't issue it, which is crazy, doesn't. Or she, and then what? So I think, my opinion is, and I'll double check, if it's a straight conviction for a violation, it probably doesn't trigger law without an order of protection.
So pretty complex, potentially a pretty complex
Tricky, yes.
topic. Clearly, you should really look at this today as a good thing, right? The Air Force has determined this is one of the important, probably not urgent things, but important things to let you guys be aware of what can affect your career. To me, my takeaway is if you find yourself in a place where you could be involved with violence, whether you think it's justified or not, you start losing control once you're involved in violence because somebody else is going to judge that, and it has ramifications. And if you're a security forces guy or you need to carry a weapon, you can expect not to be doing that for the rest of your career or probably getting out of the service. So I'll tell you, 7-8 years ago, I was up at Oswego Harbor Fest with my family, kids about yay high, trying to get a good seat for the fireworks, and picked a bad spot, sat down on the lawn, and just an army of drunk folks walking by, stepping over the family, and I just got upset, and we started getting to a pushing match, and there's troopers all around. I'm going, as I look back, that could have been an opportunity for me to get tagged, something like this. Simply thinking I'm doing what I need to do. But in the end, it's not your call. So stay away from violence as much as you can.
It's a great point, sir, because once that judge issues that order of protection, it doesn't mean you're guilty of anything. But if you're involved with a fight or scuffle, even in self-defense, like you brought up, once that order of protection is issued, you got a problem with law.
But is that against anybody? Because when I saw the slides, it was always a domestic against your family. I mean, is that if I get convicted, if I'm
Not anybody. I'm sorry, that's a good point.
order of protection.
So like what he just described, that wouldn't matter because that's
Well, you're
somebody
right.
outside his
I
family.
guess technically speaking, it's a
Why
good-
the differentiation?
Unless he was endangering his family.
Yes, it has to be domestic
Against family members?
against protected parties, which would be spouse, current spouse, former cohabitant, current
I
cohabitant.
guess my mind is going blind. I mean, if I'm
I know.
if I'm sitting next to the
Well, you're still
drunk,
gonna have
obnoxious Bears fan, I can't take it anymore, and I punch out his front tooth. That's okay.
Well, I think-
can
no,
still
I
be
don't think-
armed. It's
no,
not
I
a
don't
big
think it's
deal,
okay-
even
I
though
don't-
get convicted of
it's
assault.
okay for
That
one-
doesn't make sense.
It's okay for Lautenberg, but it's not okay for when Colonel Philcorn calls me and says one of our members knocked somebody out. I say, okay, well, I got about 50 other AFI sections I can commission under.
In a sense,
But that's a great question.
those details are important, but for the intent of what he's briefing today, if you guys have further questions, please follow up with Colonel Media. I don't know if you've got something you're doing today, so you're not available.
Yeah, this morning, I just have to go to Syracuse for some medical stuff, and then I'll be back. I will be here all weekend. So if any questions come up, please let me know. There's a lot involved with this, but I think I was able to provide you with at least some of the basics. And I gave you some practical advice on what I've seen as a judge. So any questions, sir?
Thanks, Frank.
Okay, thank you.
Appreciate it.
You're welcome.
Thank you. And as Shirk pointed out, as our next ancillary training person comes up, and I'm not sure who that is. There we go, IG. Actually, Lieutenant Colonel Jeff Brown from 174th, come on up. But I just want to highlight that hopefully the domestic violence piece, bad stuff, but again, strong bonds effort that you guys participated in, hopefully helps us as a unit to stay away from that.
Thank you, sir. Good morning. Next slide, please. So I am here to talk about the IGQ program, the Complaints Resolution Program. This is the staff at Hancock Field. Obviously, you have your own Inspector General here, Colonel Roos. You have your own IGI doing the inspections. But for purposes of complaints resolution, there's a memorandum of understanding between Hancock Field and EADS where we provide that service for you. Next slide. Okay, just run through those, please. The various functions of the IG. We're going to talk in a second or two about being the eyes and ears of the commander. The two other big takeaways from this slide is number one is we provide training similar to what we're doing today. That is a big part of what we do. We go around and we train folks. You got two more on that. The second thing is the last point there. The real purpose of what we are doing, dealing with commanders as well as you folks, is to get people back their mind to the mission. IG, I feel, is a benefit to not only be the eyes and ears, but to allow folks to get back into the mission. Because if they're talking the IG, it means there's an issue going on and they're not focused as much on the mission as they should be. Next slide.
Actually, can you go back a slide? Just to delineate what you were saying there, clearly the third bullet is IGQ. Is there any further way to say what's in your lane and that is not in Colonel Bruce's lane for IG functions?
Yes, and I'll talk about this at the end. Whenever there is a complaint, either fraud, waste, and abuse, or a reprisal, restriction, abuse of authority, a violation of an AFI, you feel that is happening in your unit, you cannot deal with it for a variety of reasons within your chain of command, and chain of command is where you always want to go first. IG is there to assist if it's not being resolved through the chain. But basically everything here, it can go in the first instance. You should talk to Colonel Roos if you have an issue. He will then forward it on to me if it's something that deals with fraud, waste, or abuse, or if it's one of those complaints that we just talked about, reprisal, restriction, any of these. And we'll get through those in the slides exactly. Does that answer your question, sir?
Mm-hmm.
Okay. Next slide. Okay, so I know there's not many technicians here, one or two. Basically, if you're in military status, the IG system is there to assist you. It can be filed at any level, okay? You can come to myself, you can go to the Joint Force Headquarters. You can also, there's a defense hotline complaints if you're not comfortable doing that. Bottom line, though, is we are going to resolve it at the lowest level. If somebody calls to the defense hotline and it's something that's appropriate for us to handle here locally, it will be referred to us locally. So you can start with the defense hotline, but in many cases, it will come back to us locally. Next slide. Okay, as I said, this is a tool for the commanders. It allows commanders to get a handle on issues that may be happening in their unit that are not coming to them directly, fix problems. Sometimes they do reveal systematic issues, so it's something that can be a benefit to commanders. Next slide. Okay, this is the first point is an important point. You know, you can come to an IG at any time, and I encourage folks to come to us at any time if it's an issue that you're not sure whether it's appropriate for the IG or not. But many times it will not be appropriate for the IG. If there are separate resolution channels available through the military, such as you don't like the EPR you got, you don't like the OPR, that will be forwarded on to a different organization to handle. The IG will not handle that, but we can walk you through that process as well. Last bullet here, the two big things, we're going to spend a little more time on that coming up, is reprisal and restriction. Those are the two biggest issues that are in our wheelhouse that we are most concerned about. Next slide. Here's just an example of the types of things that we do cover in the IG. Things that if you have an issue with, it is appropriate to handle through the IG. Let me just talk about these two things right here. You know, those they sound a little soft for the military, don't they? But there was actually a revision made recently to the IG process where it's called now retaliation instead of reprisal, and that's the idea that you cannot ostracize members. If a member comes to the IG, reports some type of problem, even through the chain of command, you cannot ostracize those people thereafter. That's a form of a retaliation that the military has now identified, and they want to try to prevent it. Next slide. Okay, those were what we do handle. Here's some examples of things that we would refer on. Okay, EO issues. You know, if there's a harassment issue and it's appropriate for equal opportunity, we will forward it on. Criminal matters, UCMJ issues. I talked about the EPRs, OPRs. Last thing, you know, I don't like if we're not there to resolve issues if you're just not necessarily getting along with folks, or you don't like how somebody treats you. That's just not something that we handle. But again, we're more than happy to talk through those issues with you. Next slide. Okay, here's the roles. Supervisor, part of the chain of command, ensure issues are resolved to enhance mission accomplishment. Personnel, you can file complaints at any level. Okay? Bottom line is communicate. You know, a lot of people ask me, what are some of the biggest examples of types of complaints that come to the IG? This is definitely one of them, where there's just a lack of communication, both up and down the chain of command. Things aren't just getting communicated. It brings a level of frustration, and then it ultimately there's a discussion involved with the IG. The other one, I would say, if you had to generalize a category of what comes to us a fair amount, is just failure to follow proper procedures. I think what I have found is that sometimes people just do things because that's the way it's always been done. They don't dig into the AFI and realize Well, there's an AFI that we had to file. So there are a number of complaints that come to us where it's an allegation that somebody did not file an AFI, and in a number of cases, those have been substantiated. So those are the two biggest takeaways I would say. Next slide. Okay, chain of command. So question comes up, what can the chain of command tell you about whether and when to use the IG system? It is certainly appropriate for commanders to tell you, we encourage you to use the chain of command to address issues in our squad, okay, or in our group, or wherever it is, in our unit. But what they can never say is, you have to use the chain of command. There always has to be the ability to go to the IG. Next slide. This will give you a sense of what we're talking about. You may think we're investigating things left and right in the IG world. In fact, it's 1% of all complaints do we actually investigate. The vast majority is this third one here. We assist folks, okay? You can get an assist without filing a complaint. Okay? You can come to us, say, Colonel Brown, here's the issue, here's what we're working through, here's how it hasn't been resolved in the chain of command, and I can assist you. I can get on the phone, I can point you in the right direction. You don't even have to file a complaint. So you should feel comfortable coming to the IG, understanding that not everything is going to be a major investigation. Next slide. So how does the system work? Typically within 60 days is when we would like you to come to us after an event occurs. You have to think through about what is the violation. I always ask folks, what is the violation? Is there an AFI violation? Or is it just, hey, he didn't treat me with respect or whatever? You have to think through that. We can talk through that when you come. The other point I want to make about this is anonymous complaints. Can you ask a lot? Can I file an anonymous complaint? Absolutely, you can file an anonymous complaint. Number one, you can file a complaint on behalf of another person. You don't have to be the one that's being offended. It can be a buddy or somebody else, or just the unit in general. But as far as anonymous complaints go, there's two ways to do anonymous. There's slip it under the door, send me a letter without your name on it or anything like that. Here's what's going on. The difficulty with those is I can never follow up with you, okay? You won't know what happened. You will have no idea if an investigation occurred, if any changes were made necessarily. The other anonymous way to file an anonymous complaint is to actually come meet with me, and then you say at that time, sir, for various reasons, I'd like to keep my name anonymous, and then we can process it in that way. Next slide. Okay. If there is an investigation, your allegations are either substantiated or not substantiated. Important point. The IG has no authority to tell somebody to change or to do things different. If there is a substantiated complaint, we will refer it back to the command, and they will make the decision. So people have this idea that we can come and we can fix things, and the IG is going to make it right. We can investigate, we can find, but once we find out, it is for the commanders to decide how they are going to fix that issue. Next slide. Okay, I talked about the two big things that we are focused on. These are the big ticket items if they come to us. Fortunately, we have not had any of these in the recent term. So, reprisal. That is withholding or threatening to withhold a favorable person action or for preparing protected communication. Bottom line, this means military personnel cannot get in trouble for filing a complaint. Protected communication. Next slide. What is a protected communication? If you could just run through that. Okay. A protected communication is anything that comes to the IG or member of Congress. You can send a letter to the member of Congress, you can send it to me. If you say anything to me or a member of Congress, it's protected. If it's through these other organizations, such as your chain of command or your supervisors or that, in that case, it simply has to be you have to reasonably believe that there is a violation of law or regulation. You see those things, gross mismanagement. So it's a little bit of a different standard for coming to the IG as opposed to coming to somebody else. But in reality, if you're coming to the IG, most of the time, it's because you believe there was a violation of law or regulation. Next slide. Okay, restriction. That's the other issue that we are concerned with. Basically, it's preventing somebody from coming to the IG. And we talked about that a little earlier. Let's go through a couple of examples of how that would play out. Next slide. So here are some classic examples of how restriction would be found. If you threaten an individual, prevent them from going, you'll drop the LOR. In this day and age, we haven't found these. I think a lot of commanders are sensitive to this issue. We have not found that to be the case here, but it's important to understand what could be restriction. Next slide. Last point I wanted to make was we obviously have a very robust inspection program now through the IG shop that's changed in the past couple of years. Is a person on the WIT, if you're dealing with somebody in the WIT and you're working through, hey, here's what's going on in my unit, and you tell them something that's sensitive or something that you believe is a violation, how the unit is processing things, that is a protected communication, even though it is not to the IG. So it's important to know that you can talk to the WIT. The WIT will then forward it to Colonel Roos, who will then forward it to me as appropriate. But the WIT are considered IG for purposes of protected communications. Last slide, please. Okay. So as I talked about, in an ideal world, you're going to go to Colonel Roos if you have an issue, and he will then walk you through it. He will give you my contact information. You can always call me directly if you need to. I can meet with folks anywhere you want to be. Off base, we can walk through it on the phone, whatever works for you. We are available to do that. And again, we are there to assist. 99% of what we do, or 90%, is to assist folks, pointing them in the right direction to help them get their minds back on the mission. So, any questions at this point?
Thanks, Jeff.
Okay, you're welcome.
Thanks for coming over. Great program. May not be the most exciting thing that we have, but clearly it serves as a check and balance to either bad process or bad decision making. But hopefully we don't have to do that. All right, unit health monitor. Let's see what we can get knocked out about this in 10 minutes or less. Thanks.
Real quick, if you don't know me, I need no introduction. Sorry. You may not recognize a new face here, Sergeant Williams. He's the ADS unit health monitor. He's a 1 July 5 previous medical background, so good fit in that position. What we're doing, just want to brief you. Every year this time, everybody's favorite time of year, we hand out the fitness questionnaires electronically. I've got a bunch of hard copy. I just want to give you a general scope of why you're filling it out, what the process is, when you fill it out, where it goes from here. There's a lot of confusion, I think. Each year we get a floodload of people coming in or asking me medical questions. They'll get with their UHM, telling them about fitness stuff. So I kind of wanted to just very quickly, 7 slides, clarify what each role is as far as the UHM and the fitness end of this process. We're going to talk a little bit about what your responsibilities are in this. Just the majority of the members fill out this form. A lot of you have seen this form before. I guess I won't pass it around because a lot of you are familiar with the form. The majority of you have no medical issues. You'll fill out. You're ready to take a fitness test in June. For the people that do have a medical issue or something's bothering them at this time, maybe didn't bother them last year, this is where we're kind of going to clarify what your role is as to take the fitness test. Discuss the role of the health monitor, myself, and take any questions. Okay. At this point, 90 days prior to the fitness test, we give each member 90 days because the medical process, we're involved with Syracuse as our host unit, and they handle all their medical paperwork. If you want to touch on that a little bit, what their process is, Sergeant Williams, do you know what medical does?
For the paperwork. Well, pertaining to this slide, where you get all your information from is your IMR. That link can be found on the various emails that get sent out to you. And it's also on the Unit Health Monitor SharePoint page. But your IMR stands for your individual medical readiness. In that page, it'll outline your immunizations, your dental classifications, and or profile information. That is where you get the bread and butter of your medical background. It's color-coded. If anything is not green, it's due. That's simply put. So it's your responsibility, like Colonel Norton alluded to, being proactive with that site. If anything isn't green, or if you handed in documentation and it should be coming undue and current, and it's still not reflecting that, email myself or the flight UHMs. I don't do that, but I'll address that later.
We time out real quick. So I'm a big proponent of personal responsibility, guys. And while we have challenges in supporting some of these things, if you haven't gone to your IMR, you guys are wrong. You need to go check it out, understand it. When you see yourselves coming yellow or red, fix it so that your commanders don't have to worry about it. Thanks.
And when you fill these out, it's obviously the member's responsibility to fill your own medical status out. You're going to turn those into me, and that at that point is your responsibility. Just get them back to me. At that point, we'll go into a little bit of what happens from there. Let's make this brief. If you answer yes, if you have any medical issues, this is where you've turned in your fitness questionnaire to me. I've noticed you've had a medical, if you've annotated that you have a medical issue. From that point on, I have nothing to do with your form. I will forward those to the UHMs, and they will, in turn, they'll get them to 174th Medical. From there, it's your responsibility to keep up the medical, keep up with your UHM, as far as if you're going to have any exemptions or what the issue is medically. A lot of times in the past, what's happened is people come to me, check weekly, daily, what's the status on my medical stuff. I don't have anything to do with the medical end of this, and this is what we're just trying to clarify. You got to learn to use your UHM. That's what their role is, and they have better contacts and a lot more information as far as where your medical paperwork is going to be at that point.
So on that topic, can you confirm for me that if an individual goes to their IMR and they have an exemption, will they see that in the database that they actually have an exemption?
We'll address that later on, but that exemption is triggered by the generation of an Air Force Form 469, which is your profile. So it's not actually you're exempt from doing a PT test. It's that within your profile, it's outlining what you can and cannot do. So.
Okay. And on that note with the 469s, during the process of when you turn these fitness questionnaires into me and test day, I don't need to see any 469s. I've got them kicked under the door, left on my desk. That's medical information that I don't need to be holding on to at that time. If you need to have a copy, if you work with your UHM, maybe they can turn it in. But what we're trying to get to is on test day, when you show up to test, you can bring that piece of paper. You bring the piece of paper so that when we're ready to test you, myself, my army of PTLs, when you show up and I don't do push-ups. We need to see the 469 which says member cannot do push-ups. We collect it at that point. Yep, member can't do push-ups. So during push-up time, you're standing around, you don't have to do push-ups. What's happened is I gave you my 469. I emailed it to you. Sergeant Sievers has my 469. You show up without a 469 from this point, you're not testing it that day. So we've just led to too many logistical errors and confusion with the paperwork. You're responsible for bringing your 469. You're exempt from that component or the test, whatever. You need to prove that directly. So just to hit on that note.
Briefly breezing through this one. Unit Health Monitor, we're literally here just to assist you. Rome is defined as a geographically separated unit, which means there's not a functioning medical treatment facility here, which sucks for you guys, for lack of better words, because it only allows you the opportunity to accomplish medical clarification items either on the one day Syracuse comes out here, or it requires you to drive an hour to Syracuse, which isn't feasible sometimes. So what we do as unit health monitors is we allow ourselves to take on all the medical information and make it an easier transition to get that to them, rather than having you have to remember the countless names associated with profiles or dental classifications or where you send information like that. So rather than you contacting Syracuse individually, we highly recommend you email it to one of your UHMs, and on the outside, email it to your flight UHMs, and they'll up-channel.
And because the medical process is for geographically separated unit, as you said, that's why we do these 90 days prior. Because I've seen it right down to test day, they still don't have their medical paperwork done. And that's could be through no fault of the member. It's just the schedule of the medical group and how civilian doctors and all that stuff you've got your paperwork and time. So it's a long process. That's why we do these so far out. So next slide. Very quickly, my role. I'll pass these out electronically. Hard copy, they'll be in the CSS. I collect them. And like I said, the majority of people who can take the fitness test, stash it and keep it for record so that when you do show up, if something does happen between now and test day, obviously address that, fill out another one, and we'll execute the process. And what I do is I take all of the ones that anybody who does have any type of issue on here that could be a medical factor, I send them to the UHMs, and like I said, I don't do anything between here and there. I'm out of the picture. I can't do anything. I've had people come up and show me swollen shoulders, and I see I can't do push-ups, and there's nothing I can do at that point. So I just want to reiterate that. The last thing I do is on test day, whether it's myself or my PTLs, we'll collect that 469 on test day. So again, between now and then, if you get your 469 a month prior to the test, I don't need to see it. I don't need to hear about it. You've done your portion of what you need to do so that on test day, show up with that piece of paper. That's all I have. That's the next slide.
This slide, the only 4 ways that you can get a medical exemption or fitness exemption are on the left side of the screen. Guys, we have 3 ways. On the right side, it outlines what steps need to be taken to get that exemption. The one thing that I want to clarify, the biggest takeaway from this, is just simply emailing a UHM your fitness letter and supporting documentation doesn't mean you have a fitness exemption. There are additional steps that need to be taken. There are follow-up appointments with fitness providers that need to be scheduled with your attendance pending, and that just gets it started. And it's not until it's actually finalized that you have your fitness exemption. So again, simply emailing someone your file is not enough. So again, being proactive. If you haven't heard back from anyone, please email, please call us. There's a number of people on the ADS side, 168 members, I think, and it's hard to keep account of every particular person. But if you take on your individual responsibility, that'll make this process a lot smoother, and we'll get you your 469 so you don't have to do push-ups.
The only thing I can add to this, if in the event that your medical process takes longer than until June when we do our fitness cycle, if you're late June, July, it's happened, August sometimes because of medical paperwork, doctors, whatever. Obviously in June we have scheduled tests, and those will be posted momentarily, probably in the next month. We'll get ramping up for that. But if you have to test after June or any time before, throughout the year, I wanted to use this opportunity to let you know, don't come to me to schedule the test. If you're enlisted, you go through your chief, and if you're an officer, you go through your commander or whoever they may designate. That's only because you could need a fitness test, but there could be 10 other people in your squadron that also need a fitness test. So I can't say, yep, I'll schedule you for this afternoon when there's 10 other people. Instead of doing 10 separate tests, 5 tests, we do 1 test, or we try to consolidate as much as we can. Plus, I don't know what your schedules are, what works best for you. So enlisted, go through your chief. Officers go through your commanders. I can't schedule a test directly, but we can test at any time. So the good note is anytime we can test, but you need to go through your chain of command to schedule that test. Next slide. The UHM's POC, information up there. If you don't know, Sergeant Sievers handles a lot of the support side in the group. He assists the security forces as well. Security forces have Sergeant Borer, and again, Sergeant Williams is for the operations. Myself, I'm the fitness program monitor, but Sergeant Zoldi and anyone in the CSS can help out if you have a question, anything like that regarding fitness. So, do you have any questions right now?
Tom, real quick. Paid announcement from Doc Kenny at the 174th. A 100% exemption from a fitness assessment is really a myth. Doc Kenny's policy is, as a minimum, you're going to get waist measured. All right, it's important. He's asked me to pass it along many times, and I feel when I do tell individuals who have 469s expired or active, the fact of the matter is that those individuals need to know, as a minimum, somebody's going to put a waist measurement around you. So during the time that you are exempt for 9 months, 6 months, 3 months, please, to some degree of fitness still needs to be taking place, and watch your weight, watch your eating habits, so on. Okay.
There's only like 3 exemptions from the waist measurement. 2?
No.
2 to 3, something like that. But very, very limited. If you have stomach surgery or you're pregnant or whatever, those are the only exemptions.
One other thing to remember too is pay attention to when your waiver expires. If you get a waiver for no run or no walk in November, pay attention to the expiration date, because if you're asked to test in June, you get back in the cycle, that may or may not take you into that month. So very important to communicate with your provider and the medical provider in Syracuse.
It's your responsibility.
Tom, real quick, did you want to? Is there an email gone out about the walkers and the current policy?
Nothing yet. I just confirmed yesterday. If anybody doesn't know on that, in the regulation, Sergeant Williams was actually combing through the reg, found a situation where if you walked instead of the run, it says in the reg, 6 months later you're due to test again if you're a walker, unless you're on a permanent cardio profile. And that left us with about a handful of members that would have had to walk again. But due to, I brought it up to a POC that I single-handedly found. Sergeant Zoldi had a POC at Guard Bureau that we kind of clarified this with, and they're actually rewording the reg. They've talked with Headquarters Air Force, and they're rewording the reg so that ANG is out of that situation. So that's been clarified, solved as of now.
So bottom line, you don't have to
Nope,
retest
if you're walking
on
during a
6 month
PT test, you're still going to test annually, just like.
So great example using the chain of command to get the right answer in a gray area. Didn't have to use IG to get it done.
That's a bullet right there for.
And digging into those AFIs for the UEI as opposed to just relying on the MICT checklist. Guys, sick of this? Sick of this yet?
It's all working.
Okay. Thanks. All right, very briefly, thanks for 30 minutes over. I'm jazzed about being the group commander now. Sad about the circumstances. Working with great people, great leadership team, and Colonel Norton, I think, is a fantastic leader for this mission. And he's gotten a lot accomplished in his short time here, and I'm sure there's much more to accomplish. So there will be changes. I look for you guys to be a part of that. Great job, great place, great mission, great opportunities. There's stuff that we haven't even discovered that we can do. Great state, great guard. So anyway, sure, anything?
Sure.
Chief?
Sir.
Chief?
No, sir.
Jens?
DSGs and staff in the ADS, please downstairs in the commander's conference room right after this. We're going to do an abbreviated commander's call down there. Just get the DSGs going.
JB?
Same for support squadron. We'll meet right here. Quick 5 minutes.
Sir?
I'll be very brief since I drank way too much coffee. Yeah, thanks for those words. Basically, we have such phenomenal airmen in this organization that our most important, if not urgent, issue is to remove the roadblocks, to let you guys continue kicking ass and make this place better every single day. Thank you for doing that. I'm just going to go ahead, because he had so many references to my initial words. Carl, here, that's your copy. Enjoy it. Pass it on as you like. And really glad to have you as part of the organization. Expecting great things from you. And I actually had a female fighter pilot in every fighter squadron I was in my career. There's not too many people that have, I've been 2.5 decades in this Air Force, and I'm incredibly proud of that fact because I think the Air Force has always been out front in recognizing, bringing in different groups of people, and just recognizing the value of having a diverse organization. I really like the fact that I'm currently in a mission set where women have contributed so much and continue to contribute. And so that diverse, there are differences. I noticed, probably about 35 years ago, there was differences between men and women. And in fact, I think in this mission set, women actually, in some ways, are wired in a way that they're probably even better at, can be better at being controllers than men. So I'm really happy to be part of that mission set. So, Amy, thanks for a great presentation. All right, guys, that's enough. Have a good one. Karen.